Reprise de débat. Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I want to start by thanking my colleague, the member for Saanich Gulf Islands, for all of her comments, which were very constructive.
For the reasons that follow, we will be encouraging all members to vote down the amendment and to vote for the bill in its current form. I also just want to take a moment to address some of the comments that were raised by my honourable colleagues from the Conservative opposition. I would encourage them to read the bill very carefully, because embedded within some of those questions were, at a minimum, some inaccurate assumptions about mandatory minimum penalties as they apply to the impaired driving regime, as well as whether or not we have the sufficient technology to test for impairment as we usher in a new era with regards to the strict regulation of cannabis. And obviously, by doing so and by reflecting on the language carefully of that bill, my hope is that we will elevate debate in this House in the interest of keeping our roads safe while at the same time safeguarding individual liberties. It's a pleasure to speak on Bill C-46, an act to amend the criminal code and to make consequential amendments to other acts. The bill will bring about the most important changes addressing alcohol and drug-impaired driving since 1969, when Parliament enacted the offence of driving with a blood alcohol concentration exceeding 80 milligrams of alcohol in 100 millilitres of blood, and authorized the police to demand a breath sample on an approved instrument. Today, I will focus my remarks on the proposal in the bill which will authorize a police officer to demand a breath sample from any driver without needing to suspect that the driver has alcohol in their body. In Bill C-46, this is called mandatory alcohol screening, Mr. Speaker, as you've heard. The enforcement tool was pioneered by Australia more than 30 years ago. It has now spread to New Zealand, the European Union, and dozens of other countries. Since then, mandatory alcohol screening has been widely credited with dramatically reducing rates of impaired driving and saving many thousands of lives, as the member herself acknowledged. The Standing Committee on Justice and Human Rights had considered mandatory alcohol screening when it held hearings on alcohol-impaired driving in 2008 and 2009. In its 2009 report entitled Ending Alcohol-Impaired Driving, A Common Approach, the Standing Committee unanimously recommended that random roadside breath testing be put in place. During its extensive hearings on Bill C-46, the Standing Committee heard numerous witnesses on the subject of mandatory alcohol screening. Professor Robert Solomon, who has written many articles on mandatory alcohol screening, as well as eminent constitutional scholars like Professor Peter Hogg, both spoke in favour of mandatory alcohol screening. Representatives of the Canadian Bar Association, the Criminal Defence Lawyers Association, and the Canadian Civil Liberties Association expressed some concerns with mandatory alcohol screening. The Standing Committee also heard from Australian experts about how mandatory alcohol screening works in that country and its effectiveness in reducing deaths and injuries. Mr. Speaker, I believe it is fair to say that the arguments of opponents to mandatory alcohol screening were based partly on their claim that it is not needed in Canada, as our current system of roadside screening based on suspicion is just as effective as that mandatory alcohol screening would have a disproportionate effect on visible minorities. With respect to the effectiveness of Canada's current suspicion-based system, it is important not only to look at the reductions in impaired driving that have occurred in Canada over the past 20 or 30 years, but to consider Canada's alcohol-impaired driving laws how they fare when compared to other countries. The comparison is grim. As Professor Solomon told the Standing Committee, quote, "One current law has left Canada with one of the worst impaired driving records among comparable countries. Consistent with earlier studies, the United States Centers for Disease Control and Prevention reported that Canada had the highest percentage of alcohol-related crash deaths among 20 high-income countries in 2013. Although Canadians drink considerably less than their counterparts, they are much more likely to die in an alcohol-related crash. For example, Canada's per capita rate of alcohol-related crash deaths is almost 5 times that of Germany, even though Canadians consume 33% less alcohol. They drink more, and unfortunately, we die more. The laws in these other countries do a better job than the laws in Canada of separating drinking from driving. Not coincidentally, 17 of those 19 countries have comprehensive mandatory alcohol screening programs." These are the words of Professor Solomon, not any parliamentarian, Mr. Speaker, a respected scholar. Professor Solomon pointed out to the committee that the experience of other countries show that going from suspicion-based roadside screening to mandatory screening has had a significant effect in reducing impaired driving deaths and injuries. As he said, quote, "The assertion that there is no direct evidence that mandatory alcohol screening is better than selective breath testing, the system we currently have, is simply false. The sharp decrease in fatal crashes that occurred in Queensland, Western Australia, New Zealand, and Ireland occurred after those jurisdictions moved from selective breath testing to mandatory alcohol screening, exactly what would occur in Canada if the mandatory alcohol screening provisions in Bill C-46 were enacted." Again, the words of Professor Solomon. The Standing Committee also heard from Dr. Barry Watson of Queensland University of Technology. Dr. Watson explained the evolution of impaired driving legislation in Queensland and the effect of various countermeasures. Queensland introduced breath testing in the late 1960s, as did Canada. Queensland then introduced a program called Reduce Impaired Driving, or RID. The police could randomly pull over other drivers, but could only breath test those they suspected of drinking. This is the system we currently have in Canada. Finally, Queensland introduced mandatory alcohol screening in 1988. This evidence strongly supports that mandatory alcohol screening is more effective than suspicious-based alcohol screening. He told the Standing Committee, quote, "The introduction of random breath testing was associated with a further 18% decline in fatalities over and above what was the case when the sobriety checkpoint program was in place," close quote. We can and must do better than we are, and I submit we should follow the example of these other jurisdictions that have been most successful in reducing the painful toll taken by alcohol-impaired driving. That means adopting mandatory alcohol screening. More troubling is the concern expressed by several witnesses that mandatory alcohol screening would lead to racial profiling. And this is a concern that we all share. We all know that there have been well-documented cases of police forces disproportionately carding or pulling over persons of colour. And as my colleague made mention, there are indeed concerning statistics with respect to the overrepresentation of our Indigenous and racialized communities in our jails. Let me be clear. Racial profiling is an abuse of police power. It is unacceptable. However, there is nothing in Bill C-46 that condones or promotes racial profiling. Our government was aware that this criticism had been levelled at the provision authorizing mandatory alcohol screening in former private member's Bill C-226. Consequently, our government in Bill C-46 proposed to specify that a police officer can only make a demand in the course of the lawful exercise of powers under an Act of Parliament or an Act of a provincial legislature or arising at common law. And I pause to emphasize that passage, Mr. Speaker, because it underscores that our government places a great value in ensuring that all law enforcement and indeed all law state actors exercise their powers in accordance with the law and with the Charter. For further clarity, our government supports the introduction of an amendment to the bill's preamble, which serves as an interpretive aid for our courts. The amendment, which was adopted at committee, states that, quote, "It is important that law enforcement officers exercise the investigative powers in a manner that is consistent with the Canadian Charter of Rights and Freedoms." Let me take a moment just to refer to you one last example of how this technology and how these standards are working in other jurisdictions. In the experience of Ireland, the experience of Ireland supports the opinion of other witnesses who have testified and other experts. There was an increase of about 10% of charges in the first year after Ireland introduced mandatory alcohol screening, but the number of charges has decreased steadily since then as Irish drivers became aware of the new law. In fact, the number of charges in Ireland fell by almost 65% in the 10 years following the introduction of mandatory screening. I believe that our courts will be able to cope with any increase in charges because many provisions in Bill C-46 will address issues that have been causing delay, particularly with respect to disclosure, proof of blood alcohol concentration, the elimination of the bolus drinking defence, and restriction of the intervening drink defence. Mr. Speaker, in closing, I want to thank again my colleague from Saanich Gulf Islands for her remarks. They were thoughtful, they were careful, they were balanced, but even she, as she admitted and conceded, there is an attempt here, a good faith attempt here to strike the balance between the need to keep our roads safe while at the same time respecting an individual's charter rights. I encourage her to support the bill. Thank you very much, Mr. Speaker.
Questions and comments? The honourable member for Sarnia-Lambton.
Thank Thank you, Mr. Speaker, and I'd like to thank the member opposite for his comments. He spoke a lot about alcohol, but not at all about marijuana. And we have 253 days remaining before this Liberal government is going to legalize marijuana. So my question for him is, what test will be used by police and the RCMP across the country to test for marijuana impairment, and what is the limit that will be considered the maximum allowable?
The Honourable Parliamentary Secretary to the Minister of Justice.
Mr. Speaker, I want to assure my honourable colleague that after careful consideration of expert evidence as well as development of new technologies, that we will have the appropriate road screen device testing abilities to ensure that we can measure impairment as it relates to cannabis. And indeed, this is a fundamental part of ushering in a new strict regime when it comes to regulating access to cannabis. We know that the current approach to regulating cannabis is not working. I have some experience in the criminal courts with respect to this. I'm very proud of the work that this government is doing to ensure that we keep the cannabis out of the hands of our children and keep our roads safe, and this bill will accomplish both of those important objectives. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for South Okanagan, West Kootenay.
Well, thank you, Mr. Speaker, and I wanted to follow up on the question from my honourable colleague who asked about marijuana and roadside tests, because I was on the Justice Committee meetings when we heard from the Australian police about their roadside tests. We also heard from an expert from California, from a university there, who studies all his studies are to do with the relationship between impairment and what you get from drug tests for THC levels in blood and mouth swabs. And basically, there's no good test right now that exists. There's not even any hint that we will have a good test in the next year or 10 years because of the way that THC works in the body's physiology. So I just wanted to ask the member again, you know, what test is he talking about? Because we heard of nothing of the sort in committee. Thank you.
The Honourable Parliamentary Secretary to the Minister of Justice.
Well, I sat through those very same committee meetings, and I have to correct my my honourable colleague that there was indeed much testimony in the way of the technologies that are used in other jurisdictions and how they are evolving and how they are improving. We have something called oral fluid drug screeners, which will allow us and law enforcement actors to measure THC levels. And we will ensure that we have an appropriate threshold to measure what is impairment for the purposes of keeping our roads safe. I encourage my honourable colleagues to read the bill very carefully, to read and to follow the debate as it evolves in this House, because we are going to get this right, Mr. Speaker, and I'm very proud of the work that this government is doing to move forward with a cannabis and a drug impairment regime that all Canadians can be proud of. Thank you, Mr. Speaker.
Questions and comments. The Honourable